Recently, the Supreme Court denied review to both the rifle and magazine ban challenges that were pending in front of them. In that denial, they pointed to multiple cases that they will be watching, including this challenge, which was prior GVR'd by the Supreme Court. That case is currently heading for oral arguments in the Third Circuit, and right now this is one of those critical cases that we have to watch going forward because it could be the next one that ends up in the Supreme Court. So let's talk about what is happening. Now, before we jump into this video, if you want to support the channel for free, one of the best ways to do that is to simply like, comment, and subscribe. Obviously, subscribing to the channel helps the channel to grow. Also, double check to make sure YouTube is not unsubscribed to you because that happens quite often. And then just drop a positive comment down below because that tells the algorithm that you appreciate two-way content and it should share this video to more people. As I mentioned in the intro, in this video, I'm going to be discussing two critical cases, one which deals with a state's rifle ban and the other the state's magazine ban. This magazine ban case was recently GVR'd, meaning it was granted, vacated, and remanded back down to the district court for a new decision in light of what the Supreme Court said in the 6-3 Bruen decision. Well, that district court recently issued a decision in two consolidated cases called ANJRPC versus Platkin and then also Cheeseman versus Platkin. And in that ruling, the court came to one of the more confusing and kind of outrageous anti-Second Amendment analysis that I've really seen in a long time. The court found that the state's ban on Colt AR-15s is unconstitutional and must be struck down. However, in the same brief and in the same opinion, the court decided that the magazine bans in the state were constitutional and upheld those magazine bans. This egregious decision has now been appealed to the Third Circuit Court of Appeals and has been set for oral arguments to happen really soon at the end of this month. This case also just became even more important after the Supreme Court denied review to the Snope and Ocean State tactical cases. This Third Circuit case was recently also mentioned in that denial by Justice Kavanaugh, and he stated this is one of those potential cases that could make its way back to the Supreme Court, maybe next term or a couple terms, and this could be one of those cases that they grant review to, but it's one of the cases that Kavanaugh expressly pointed out as a case the Supreme Court will be watching. Now, this case involves the state of New Jersey's ban on so-called assault weapons and their magazine bans as well. When it comes to the magazine ban back in 2018, the state of New Jersey passed Assembly Bill 2761 and banned the possession of certain firearms magazines that hold more than 10 rounds. In August of 2018, the district court on review denied ANJRPC's motion for a preliminary injunction, and then it went to a final merits determination, and of course, once again, the lower court ruled against ANJRPC. This was then appealed to the Third Circuit by ANJRPC, who argued that once again, this magazine ban should be struck down by the Third Circuit. However, the Third Circuit ruled against ANJRPC. At that time, ANJRPC tried to get an en banc panel review in the Third Circuit. However, that petition was denied by an 8-6 vote in the following month. That then led ANJRPC for the first time to go to the Supreme Court for cert on the final merits back in 2022. But then this case was remanded back down to the lower court because the Supreme Court issued that 6-3 decision in Bruen. The district court then reviewed this. They consolidated this ANJRPC case and the Cheeseman case, which dealt with rifle bans. The court reviewed it and then issued its decision. In that decision, the district court showed essentially how they're not going to faithfully apply Bruen at all. The judge believes that the Supreme Court kind of got the analysis wrong in Bruen, and the judge decided to kind of create a hodgepodge decision, kind of skirting Bruen as best as he could to reach the conclusion that he wanted. In the ruling, the district court stated that it is hard to accept the Supreme Court's pronouncements that certain firearms policies choices are off the table when frequently radical individuals possess and use the same firearms for evil purposes. Despite that, the court stated it was bound to have to follow Bruen in some way. And that's what led to the hodgepodge decision in these cases. When it came to the rifle ban, he found that given the variety of firearms regulated by this law and the nuances that each individual firearm presents, the court's analysis of this law is limited to the firearm which the court has been provided the most information, the AR-15. The court decided to arbitrarily then limit review in this case to just AR-15s and ignore all the other semi-automatic firearms and rifles that were included and regulated by the New Jersey law. On review, he found that the Colt AR-15 ban was unconstitutional, did not align with Bruen, but again, he ignored all the other rifles and firearms that were regulated by this specific law. He then went on to look at the magazine ban in New Jersey, but the judge kind of did everything he could to twist Bruen and ultimately reach the goal of finding that these magazine bans were constitutional. The judge found that magazines are arms within the meaning of the Second Amendment, so he had to essentially follow Third Circuit precedent that said, yes, magazines are arms. That's precedent in the Third Circuit, so he said, yes, these are protected arms. He also found that magazines that hold more than 10 rounds are clearly in common use. So not only did he say they're arms, but they're in common use. But then he deployed what is known as the more nuanced approach based on new societal concerns to uphold the magazine ban and say that magazines with a capacity of more than 10 rounds could in fact be restricted by a state. So in that decision, the judge struck down only a narrow part of the rifle ban there, dealing specifically with AR-15s. He avoided ruling on all the other firearms. And then at the same time, he upheld the magazine ban. But this horrible decision is now being appealed to the Third Circuit Court of Appeals. And this is good because it's also on the final merits, and it's a case that was prior GVR'd by the Supreme Court. Now, in the appeal, the plaintiffs argue that the court started off on the right foot, holding that the New Jersey ban on AR-15s, America's most common civilian rifle, is unconstitutional. But the court then arbitrarily cut plaintiffs' challenge to all of the rifles, pistols, and shotguns in New Jersey, and all of them that they outlaw as assault firearms, down to just the most popular one. That is inexplicable. To be sure, plaintiffs sometimes use America's most popular civilian rifle as an exemplar of the kinds of firearms that New Jersey prohibits and what it encompasses, but that in no way negates the pages and pages of summary judgment briefing, expert declarations, and pleadings that the plaintiffs supplied addressing the full suite of firearms that the state has banned. Meanwhile, as to magazines, they state, the district court correctly held that the banned magazines are arms covered by the Second Amendment's plain text. It recognized, too, that they are in common use for lawful purposes. But things went south from there. In attempting to apply a nuanced version of analogical reasoning, the court suddenly, and without explanation, held that the state's ban on possessing these arms was merely a restriction on how people may use them. Now, New Jersey has responded to this appeal to the Third Circuit, and they're now trying to use the recent Ninth Circuit decision out of California in the magazine ban case Duncan, and they're trying to use that as support for why their state can also ban these types of magazines. In the recent notice to the Third Circuit, New Jersey states that the state advises this court of Duncan versus Bonta, which rejects Second Amendment and takings challenges to an equivalent state restriction on these types of magazines. The Ninth Circuit is now the fifth post-Bruin circuit to reject plaintiffs' claims, with none holding to the contrary. They state that as for the Second Amendment, Duncan upheld these magazine restrictions on two grounds. First, it identified a tradition beginning before the founding and continuing throughout the nation's history of legislators enacting laws to protect innocent persons from especially dangerous uses of weapons once those perils have become clear. It invoked, in particular, restrictions on trap guns, bowie knives, slingshots, concealable pistols, and gunpowder storage, the history New Jersey details here. And it held that the more nuanced approach was appropriate in reviewing this history because this dispute implicates both unprecedented societal concerns and dramatic technological changes. They state the court also rejected plaintiffs' simplistic approach that because many firearms owners own these magazines, that should be the end of this analysis. The court explained that this approach was weak and inconsistent with the animating Second Amendment principles and precedents. And the Ninth Circuit added it conflicts with case law on machine guns, noting that plaintiffs do not explain why under their ownership statistics theory, 176,000 machine guns is insufficient while the somewhat larger but unknown number of magazines suffices. Duncan also rejected the Second Amendment claim because magazines like these as accoutrements are not even arms, nor are they necessary to operate any firearm. So the plaintiffs in this case have now taken this challenge back to the Third Circuit on the merits, on a summary judgment granting of the lower court. This happened after Bruin, after this case was GVR'd, and they're now asking for the Third Circuit to strike down what the lower court said, essentially say, yes, the rifle ban portion about AR-15s was correct, but to limit it just to, Colt AR-15s was improper, and then to also uphold the magazine ban was also improper under Bruin. The Third Circuit will now hear arguments and decide whether they will follow other circuit courts like the Ninth Circuit on magazine and rifle bans, or will they be kind of the first ones to find that the Second Amendment and the recent Supreme Court decisions in Bruin actually barred these type of state actions. It might be a long shot for the Third Circuit to rule in our favor, but it would create a very critical circuit split that maybe the Supreme Court is saying that they want right now. And this has also become even more important. This challenge specifically in these oral arguments are very important because Kavanaugh, after the denial of Snope and Ocean State Tactical, said in his statement that the court would be addressing this issue potentially next term or soon, maybe in a couple terms. and mentioned these challenges expressly as something that he's going to be watching and that the court will be following. Now, I will note that that probably could be an empty promise. There is no guarantee the Supreme Court is going to even want to take a rifle ban or magazine ban next term or future terms. And there's no guarantee that just because they mentioned these cases expressly, that if these make their way to the Supreme Court, they would grant review to them. But it does mean that we need to be watching these to see how they develop, because the Supreme Court has pinpointed them as cases of interest. So this is an appeal we're going to be keeping close eyes on, and it's going to be interesting to see how the Third Circuit handles these during those oral arguments that are happening at the end of this month. And as we get more information, as that comes out, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, the station was built by armed scholars, and the station will be maintained by armed scholars.